It's a sad fact that creditors can and in fact do garnish wages, but a lot of things need to happen before a creditor can garnish wages. First, you have to default on the debt. Then, the creditor has to file a lawsuit against you. After filing the lawsuit, the creditor has to serve you with the papers in the lawsuit. And finally, the creditor has to convince the court that you owe the money and get a judgment. So, generally speaking, a creditor can't garnish your wages until they've taken all of these steps. There is one exception, and that exception is federally guaranteed student loans. Federal student loan law is one of the very few cases in America that have no statute of limitations. The requirement that you need a judgment before you can garnish on federally guaranteed student loans also does not exist. This means that if you don't pay a federally guaranteed student loan, the Department of Education simply has to write a letter to your employer that says it's time to garnish your wages. Now, that is only for student loans. With credit cards, auto loans, home loans, and with every other kind of debt, the creditor has to get a judgment against you. But even if a creditor does have a judgment against you, there are many exemptions to garnishment in the state of Florida. My favorite exemption from garnishment is the head of household exemption. What it says is that if someone provides more than half of the support for a child or other dependent, that person is exempt from garnishment, whether or not that person owes the money. Furthermore, Social Security, pensions, and veterans benefits are all exempt from garnishment. The best way to find out if you're exempt from garnishment is to call a lawyer and find out your rights. If you have any questions about garnishment, about judgments, or anything having to do with credit cards, give us a call or drop us a line.